Welcome back again to Bankruptcy with Ben. And I want to cover another update on Forever 21. If you recall, we previously discussed how Forever 21 was an up and coming fast fashion retailer which found itself in bankruptcy yet again. I say yet again because Forever 21 had previously filed in 2019. So now, for the second time in 6 years, a major retailer named Forever 21 is back in hot water. So what happened? How did they get here? We discussed a lot of that previously. They blamed a lot of it on tariffs, and there was a loophole in the tariffs which allowed goods of $800 or less to be excluded from tariffs. So Forever 21 claimed that other foreign companies that shipped directly to consumers that had competing products with them were able to avoid these tariffs, and therefore really didn't put them completely out of business, but really harmed their business because they were able to take advantage of a tariff loophole that Forever 21 could not take advantage of. Now, there's a whole other saga to this, completely nothing to do with the tariffs. And that is what is being alleged as, maybe they don't quite say it outright, but there's a group of creditors that says that they want to investigate a deal that Forever 21 entered into before bankruptcy with JCPenney. And this latest comes from Bloomberg. So let's dive into this Bloomberg article and let's see what's going on. So we have here from Bloomberg, a committee of unsecured creditors to Forever 21's U.S. operator said they are aggressively investigating all deals made by the retailer before it filed, including JCPenney's acquisition of the operator's parent Spark Group. Okay, let's unpack this. When a company files for bankruptcy, broadly speaking, there's two categories of creditors. There's secured, there's unsecured. Secured is called secured because they're in a secure position. They're safe. Why are they safe? Because the money that they lend is backed by collateral. The same way that you borrow money to purchase a home, the bank has a mortgage on your property, meaning that the loan the bank gives you, if you don't pay it, the bank is secure, they're protected. They can come in and they can take your house and resell it and they'll pay themselves back. That's collateral. So secured creditors have certain rights. Unsecured creditors are creditors, or it could be anybody that is owed money by this bankrupt company, but the money they're owed is not backed by any kind of collateral. Very often that comes in the form of vendors, right? If you have a vendor, somebody that sells, let's say, I don't know, t-shirts to Forever 21. So they can ship Forever 21 $100,000, $500,000 of t-shirts. And if Forever 21 doesn't pay them right away, which typically, again, businesses often operate on what's called net 30, means that within 30 days of being shipped all the goods, they pay for everything that was shipped in that previous 30-day period. So it's not being paid as it comes along. They pay it out at a later point in time. That just helps businesses operate more smoothly. So these vendors are often unsecured. They're not protected by any collateral. Okay. So the unsecured creditors, they come together and they form a committee. So they kind of pool their forces together and they operate almost as one kind of unit to say, we're all speaking as a unified voice rather than having 100 different creditors saying 100 different things. They come together. We're one voice saying one thing to help all the creditors that are part of this committee to have a little bit more of a voice. Okay, that's the background of what's going on. Now, the other thing to remember is if a company is in bankruptcy, there's a lot of news, a lot of headlines that will say, ABC Corp exits bankruptcy, slashing 60% of its debt. It sounds like it's crazy. Like, what? How did that happen? How does a company just get rid of 60% of their debt? It almost doesn't sound fair. And you're right, it's not fair. But the bottom line is, if the company, due to either their own missteps or unfortunate circumstances, does not have the means to repay their creditor, well, you can't squeeze blood out of a stone. So if there's not enough money to repay them, if the company had not filed for bankruptcy, who's to say the creditors would ever get paid anyway? So the bankruptcy, at least it allows them to get something. Whereas if the bankruptcy were not filed, they would simply get nothing because the company had taken such poor steps, let's just say, in managing their operation. It's not even necessarily the company's fault. Sometimes there's just unfortunate circumstances. So it really depends on, which prism you look at. So with that background in mind, back to the article. What are they looking at with JCPenney? What exactly do they want to do? So they say here, the acquisition joined and obligated Forever 21 and certain affiliates to pay JCPenney's existing debt, the committee alleged Thursday. That's the key thing. They're saying, we're already owed money. And what happened? Forever 21 goes into some agreement with JCPenney and says, well, we're owed a lot of money, but it doesn't matter, JCPenney. We're still going to pay your debt. So it's like, you guys didn't have the money to pay us, and now you're paying someone else. That doesn't sound fair. So that's the crux of the complaints that that the creditors are claiming. How does this all fit into the picture? Well, the committee said it would investigate the transaction. How? As part of a broader written objection to the company's request to tap lenders' cash. What does that mean in plain English? Again, back to our analogy of a bank giving a mortgage. So there's secured creditors and there's unsecured creditors. One of the rules in bankruptcy is that if a company wants to operate, they need permission, generally speaking, from either one or both of either the creditors or the bankruptcy court to use cash in order to operate the business if the cash of the business is subject to a lien from another creditor. Now, what does that mean? So what's, again, back to our analogy with a house. The bank is a mortgage. The mortgage is backed by a property. What is another kind of collateral that you could take to protect yourself? You can also say, well, if you don't have real estate or you don't have other substantial assets to protect me, so a creditor that's giving a loan will say, well, the same way you can give a house or piece of real estate as a collateral, you can give your cash as a collateral. So the cash of the business is now going to be subject to the lien or to the claim of a creditor. So they cannot use the cash that's subject to the creditor's lien without getting permission from the creditor or from the court. So what are they saying? They're saying we want to tap the lender's cash, meaning we want to use the cash that the lender has these lien rights in order to operate the business. So now going back, why would a lender agree to that? If you're a creditor, you say absolutely not. You've already burnt through all your cash. What is to protect me from you just burning through more cash and never paying me back? But this is where another interesting point comes. They say, okay, no problem. We're going to give you something else. We'll sweeten the pot. we'll give you an additional collateral. What is additional collateral? And this is actually very creative. It's not generally thought of in kind of regular parlance, but it's actually done quite a bit in the context of bankruptcy. And that is, they're going to say our rights to bring a claim against any third party that might have wronged us. Well, we're going to give you, these creditors, we're going to give that right over to you. So now you as a secured creditor are going to step into our shoes. And if we were able to make a claim, let's just say against, Uncle Bob, who owned the company, and Uncle Bob was mismanaging the company. He stole, let's just say Uncle Bob is our fictional CEO of Forever 21, and Uncle Bob was siphoning millions and millions of dollars from the company and using it for his own personal gain. Well, the company could say, well, we have the right to sue Uncle Bob because he stole all this money from the company. And if we win and we can get millions of dollars back from Uncle Bob, well, that will help the company. So they're going to say, okay, you creditors, you step into our shoes. You have the right to now sue Uncle Bob to get this money back. Now, back to our case. How does it relate to our case? So the creditors are saying, well, the secured creditors and Forever 21 have reached an agreement where they're going to say these claims that we might have against other parties, we're going to give it to you, the secured creditor. And what's one of those claims potentially? It could be a claim against maybe JCPenney. Why? They want to see, was the deal kosher, for lack of a better word? Was it proper for Forever 21 to take on all of JCPenney's debt when they owed all this other existing debt? So these creditors are saying, well, we want the right to be able to sue JCPenney, or at least investigate whether or not JCPenney can be sued. And that's the heart of the debate here. So just to recap, Forever 21 says, court, we need cash to run our business. Lender, secure lender, you otherwise have the right to take our cash. So what are we going to do? As a exchange for letting us use your cash, we're going to give you the right to sue someone else. Unsecured creditors, on the other hand, say, wait a minute, that's not fair. We're owed money, and you entered into this shady deal with JCPenney. We should have the right to sue JCPenney. So that's what's going on here. Now, let's see if there's any other kind of nuggets that we can get from this article. Spark, which operated for Forever 21, Aeropostale, and other fashion brands, announced in January that it merged with JCPenney to form a new company, Catalyst Brands. So Spark had operated a whole bunch of companies, including Forever 21. And now they're merged together with JCPenney, and we have a new brand, Catalyst Brand. Now, Forever 21's intellectual property, meaning their own designs, their own logos, all that kind of stuff, which could be very valuable, is owned by Authentic Brands Group, so another company, and they licensed the brand to the retail operating company that filed bankruptcy, Forever 21. So it's a whole complicated scheme, but essentially, the intellectual property is another large asset that now there's going to be disputes among the creditors who has the right to potentially take that asset and maybe sell that asset and get some money. The committee's Thursday's court filing said vendors and other unsecured creditors will be net losers, in part because the bankrupt operator appears to have sold their valuable Forever 21 intellectual property assets prior to the Chapter 11 case. So A, they entered into this terrible deal with JCPenney. B, they sold their intellectual property, so they don't even have it anymore. The creditor group also said Forever 21 extracted significant discounts on goods shipped just before the bankruptcy filing, meaning all the goods that were shipped to Forever 21, Forever 21 probably said something along the lines of, give us a discount for this because otherwise we just can't pay for it and everyone's going to lose. And now they're saying, well, in bankruptcy, we'd be able to get full payment on that. But now you kind of tried to negotiate us down in a sense where, we're now in a weaker position. So just to wrap up, Forever 21, it said it was a fashion brand targeting young women founded in 1984. They're liquidating all U.S. stores, and the recovery to creditors are saying is between 2 to 3%. So you can understand why creditors are so unhappy. A 98 or 97% loss is extraordinarily significant to ask a creditor to bear. And that's why they're going to be fighting so hard to really try to recover every penny that they can get. Next hearing is scheduled for Tuesday. Okay. So that's the kind of basics of where we're at. The important point, just to wrap up, if you're a creditor, you sometimes have to think out of the box. And when two parties in a bankruptcy are making a deal with each other, if you're a creditor, you have to think, how does this deal impact me? How does it impact my rights? And if there's no physical, tangible assets for me to recover right now, well, then maybe there's some maybe there's some non-tangible assets to recover. And it goes to show creative thinking can also hopefully lead to creative solutions. It's going to be very interesting to see how this one plays out. Forever 21, maybe forever no more. We'll see you all on the next one.